Well, good afternoon from here in London, and I'm delighted to welcome you to an FS Club webinar, The Post-Pandemic Office, Legal Rights and Responsibilities. And we have with us two guests today from Keystone Law, Cordelia Rushby and Alexandra Carn. I hasten to add, we're going to be speculating about stuff that I know we're all very interested in, what's going to happen post-pandemic to the office, but we're taking a particular view today, and that's the legal rights and responsibilities in the office. So we're not going to be covering issues like taxation, probably not exactly the office layout, but what are the changes that face us ahead? Now, you'll know me, I'm Michael Mainelli. I'm one of the directors of Zien, and it really is a privilege to be able to introduce so many of these webinars, largely because our sponsors, whom you can see here, are extraordinarily tolerant and allow us to range widely and freely across technology, economics, and finance. But hitherto, all of that has been occurring within the physical office. So how is this going to change our relationship as a firm, our relationship with our employees, with our employers, etc.? So it should be fun and interesting today. Now, we're going to follow a format I think many of you know. I'll get out of the way as quickly as I can and leave you to the experts. Cordelia and Alexandra are going to speak for about 20 to 25 minutes, and then we'll move into Q&A. Please use the question and answer facility here in the GoToWebinar system. I'm online with you now, and so I won't be able to see your texts or your emails. So do use the system facilities. And just to knock off a couple of quick things, the recording will be up in approximately 2 days. The slides are already posted there and we will be available. And all of the questions that you submit will be sent to Cordelia and Alexandra. So if there's a point of great detail, I will be forwarding those to them and they can answer you directly because they'll have the email. So with no further ado, if I may, can I suggest that Cordelia, the floor is yours.
Thank you. I think you've got a poll for us first.
Well, we do indeed. You wanted to know a couple of things, so let's have a quick look at the polls. I'll launch this first poll. Has your business already published a COVID-19 office risk assessment? So yes, no, or don't know. As ever, I'm stunned at our FS Club members who have answered. Over 75% have answered already. I'll give it just a couple more seconds. And I'm now closing that poll, and I'm going to share those results. So Cordelia, you should be able to see that now.
Okay, so tremendous. Hats off to the 57% who've done a premises risk assessment. Listen on and you'll find out if you've covered all the things you need to cover. The 25% who haven't done one, if you've got anybody working in premises today, I suggest you phone them up and tell them to go home, and you'll find out why that is later. The 18% of you who don't know, that is worrying, as you'll come to see, because any risk assessment that's been done should have been communicated to the workforce. So if one's been done, you should know it. If you've got over 50 employees in a business, it should also be published on your website. So thank you for doing that poll. And then we just got one other little one to do.
We do indeed, and I'll just launch that right now. And this one is, very much, has your business advised home workers on how to undertake a home office risk assessment? And again, very fast off the mark, our group. So we're really rising there. 74% have voted. So just a quick second there. All right, I'll now close that poll and share the results with you, with well over 80% having voted.
Okay, again, looking good. Just 64% of you there have done some home office risk assessments. 27%, that's 30%, that's really too many, feel that probably home office risk assessment hasn't yet been done. We're going to address that towards the end of my talk. And 9% don't know. That's forgivable if you don't work from home. If you do work from home, then if one had been done, as we made the point previously, the risk assessment should have been given to you so you'd know if it had been done or not. Okay, well, hopefully that's whet your appetite for the issues that we're going to cover in the talk.
Well, Cordelia, you'll find it interesting. Greg Davis, and I guess we're getting into month 12, points out we're on version 12 of our COVID-19 risk assessment.
Excellent. Excellent. And actually, I'm just going to come right onto that point now. which is risk assessment should be dynamic and they should respond to the multiple changes that are happening. So, you know, everybody should be striving to be on version 12 because that shows that it's fluid, it's dynamic, and you are responding. So well done. So if I could have the next slide. So I'm just going to give you a whistle-top tour of the law that applies for those who have got employees who perhaps are skeleton staff in premises at the moment, those who are thinking about reopening premises and getting people back to work, and also for people who are working from home and they're trying to deal with home office home workers at present. So the law is the law that you've always known. It's the common law duty of care to take reasonable steps to prevent foreseeable harm occurring to staff. The Health and Safety at Work Act sets out the statutory duty. You need to ensure the health, safety and welfare of every employee so far as is reasonably practicable. So the good news is that that is a test of reasonableness. You haven't got to be perfect, you've just got to have assessed the risk and responded reasonably. But these duties that you've always known about, they apply just as much to home workers as they do to those in the office. Next slide. In addition to those very basic points, health and safety regulations support the Health and Safety at Work Act, and if you comply with the regulations, you'll be going some way to complying with your duty of care. There are also enforcement measures to think about. They're the regulatory aspects of health and safety law, and they're implemented by the Health and Safety Executive in the UK, who we call the HSE. Now, they've intentionally taken a back seat with health and safety over the last 10 years or so. They've become more an advisory and guidance body. I think really in response to public criticism that people, you know, were being tied up in red tape and couldn't run their businesses properly. Well, with COVID, all that has changed overnight. They have dramatically increased the number of inspections that they're doing. They've done that by pulling in external consultants and basically retaining them as inspectors. And all over the UK now, spot checks are happening in all types of businesses. So be very aware of that, because businesses are not used to having on-spot checks by health and safety inspectors, and many have forgotten the wide-ranging powers that they have to request that documents are produced to them there and then, to take documents away, to interview staff, and if they find unsafe practices that are giving rise to imminent danger, they can shut your office or your premises straight away. So they have vast powers. It's worth looking them up. Then the other aspect that you'll be being bombarded with at the moment, particularly those on version 12 of their risk assessment, is the government guidance, the guidance out there on getting premises back up to scratch when they've been shut down, ready for staff to come back. And also there's lots and lots of guidance on working at home. That is all available on the gov.uk website. So how are you going to, you understand what your duties are now, how are you going to prove compliance with your duties? Well, you have the same liability for accident and injury to home workers as you do to office workers. How are you going to discharge that duty? Well, you're going to assess the risk, taking into account all the available information and the ever-moving guidance. You're going to set up a safe system of work. You're going to implement and monitor that, and then you're going to support that with training and supervision. That, in a nutshell, is how you pick your way through all the mind field at the moment of data and advice. Next slide. So what is the law? What are the particular regulations around COVID that you should be worried about? I've just stuck them on the slide there for you. You can come back to them later. If someone says to you, why do we need to do a risk assessment? There's your authority. Management of Health and Safety at Work regs, or COSH, the Control of Substances Hazardous to Health. Now, with COSH, anybody who's involved in HR or compliance, they'll be thinking of chemicals in the cleaner's cupboard. No, as we see in a minute, COSH includes biological agents, which is COVID. So the Management of Health and Safety at Work regs says you must carry out a risk assessment relating to known risks. COVID is a known risk. Next slide. So COSH there says You need to assess the risk arising out of biological agents that are hazardous to health, and that includes viruses. The good thing about COSH is it absolutely specifies the employee's obligation to comply with any risk assessments that you put in place around that risk. Next slide. So COVID risk assessments, this is for your premises. I'm thinking of people who've already got skeleton staff in, or where premises have closed and you're hoping to reopen them at some point in the next 6 months. You need to do a COVID premises risk assessment. Where do you begin with it? Well, sort of some very basics there to get your head around it. You're thinking about the premises. So what have you got? What's your infrastructure? Who uses them? Who comes onto your premises? Contractors and your staff. What have you got in those premises? Equipment. How do we safeguard people from using those if they're going to give rise to risk? Then you need to think about your staff. Are any of them in vulnerable groups? The government website, very intricate details of who all the vulnerable groups are and why. Age, gender, BMI and ethnicity are the absolute key deciders that significantly increase risk. So you need to know about your workforce. How are you going to do that? Are you going to issue questionnaires? Are you going to ask them details about their medical history? Or are you going to take the opposite approach and get them to confirm that they don't fall into any of those groups? Many are taking that option, but I don't see many ensuring that that's essentially an informed consent scenario. If you're going to supply disclaimers, have you given, and I think the best thing to do is the government list, the list of what the vulnerable groups are and where the vulnerabilities lie? People need to be able to know what it is they're saying they're not falling within, if you're asking them to do it by a disclaimer. Then, of course, if you're asking for medical information, how protected are you via your privacy policy for handling that personal sensitive data? That needs looking at. Next slide. So the question is, when you've got this risk assessment together, taking into account the control measures that you have built into your risk assessment and subject to the current government guidance, should staff only be working from home, or with your appropriate prevention and control measures that you've got in your risk assessment, is it now safe to work in the office? Can they work safely? And that is the question you're looking to address. No employer may require an employee to work in an unsafe environment. And if you don't have a COVID-19 risk assessment, or if you do have one, but it's just paying lip service to risks, or if you do have one, it is a beautiful document, it addresses all the risks, but nobody's enforcing it, you are running an unsafe office environment. You've got to disseminate the information. When you've got your risk assessment, it needs to be shared with the whole workforce. The government have also issued guidance that if you have 50 or more workers, it should also be published on your website. That's because health and safety legislation doesn't just apply to your workforce, it applies to those affected by your undertaking. That's the statutory explanation. I like it, it's a bit windy, but I like it because it reminds you how very broad your duty is. Those affected by your undertaking. Everybody from a delivery driver who comes in to drop a parcel off to an electrician who comes into the bowels of the building and works on the electrics. These are all affected by your undertaking. You should be considering them in your risk assessment. Next slide. You then need to communicate the risk assessment and your new COVID procedures. Many organisations are finding that the best, most sort of consolidated way to do that is by preparing a COVID office policy. That's the document you're going to use to communicate to staff what your standards are, what they need to do and how they need to comply. And that will then support your findings of your risk assessment. So you need to set a very clear policy for those, if they become sick at work, what are you going to do about notifying close contacts, requiring self-isolation, ensuring the area is decontaminated. So the risks arising from people becoming ill at work are really wide-ranging, and they're not risks that you will have considered in other risk assessments. So very much a new era. Next slide. So that was a whistle-stop tour of premises. The other issue that I'm going to look at is homeworking. The good news is, guess what? It's happened before. It's not new. There's a very old guide sitting on the HSC website that talks about loan working. And within that document, there was reference to home workers. It's been long established that your health and safety duties to your employees applies just as much to those in the office as to those who work remotely. This is not new. It's just that many employers haven't really thought about it in depth before. The very important point to remember is that the word employee in this context, in a health and safety context, is quite different to an employment law context where HR officers and perhaps employment lawyers like Alexandra, you're liaising. You're always thinking of who's got a contract of employment. In health and safety law, you're looking at the much broader remit of people affected by your undertaking. So that's contractors, freelancers, the self-employed. So you need to look at what work is being done at home. You need to assess the risk. You need to do the same training, supervision and monitoring, and you need to keep in contact. Next slide. The latest guidance, the HSC have updated their guide and it's called Homeworking. It's very much focused on keeping in touch. How are you going to do it? Knowing what your staff are doing at home. Is it being done safely? Are control measures needed to protect them? There's a real focus on dialogue all the way through all the current guides. There are phrases like meaningful exchanges with employees. There needs to be meaningful dialogue. What are you doing? What do we need you to do? How are we going to help you do it safely? Then you prepare the risk assessment. That needs to be provided to all your workers. And there is the point, monitor its implementation and adapt. Next slide. So for those of you who think a risk assessment for home working is an impossible document to produce, because how would you possibly know what every single person's home office looks like? I encourage you to seize the bull by the horns and to produce a document. It is definitely possible to produce a fairly generic document looking at the common risks that arise from home working. And just to get you going on that, in the next couple of slides, I've just given you the 3 key risks that need to be addressed. So you need to look at ergonomics. So typically a risk assessment identifies the risk and then it puts in place measures to either remove the risk or to reduce it to the lowest possible level that will result in no injury. So here's your risk, poor workstation ergonomics. What's the consequences? Could be musculoskeletal injuries. How are you going to mitigate that risk? Well, you're going to give advice to your staff about setting up their workstation, thinking of things more laterally like environment, temperature, lighting, posture, reminders about rest breaks. You need to assess your workers, of course, and identify who's vulnerable and might need extra care. The Chartered Institute of Ergonomics have done a really excellent pictogram, helping people at home set up their workstation in a really good way. If you drop me an email afterwards, I can send you that. And I recommend that you send that out with your home office risk assessments. There's good news on display screen equipment. Those of you who are responsible in the sort of typical office environment for display screens know that there's quite a challenging display screen equipment evaluation that has to be done. The HSC says they're using that equipment at home, but really the risk arises out of long-term usage, which at the moment we're not thinking is going to happen. We're hoping home working is fairly temporary. Of course, we are expecting that many more people are going to be remaining home working, so that is definitely a risk you'll need to return to as you decide that you've got more home workers. They're going to be increasingly exposed to DSE risks at home. The HSE have published a workstation checklist. I think it's fairly rubbish. I'm sure you could improve it with a standard office-based desk risk assessment. I think you could combine 2 documents there. Next slide, please. The second risk there is reduced technical support and supervision, leading to stress and poor performance. This is really talking about the technology and the changes that you're requiring your staff to deal with from home. Problems with not having adequate tools online. You can address that by training. You can also address it by supervision. The HSE recommend that you keep in regular contact with your staff to make sure they're healthy and safe. And in an environment where ITU consultants have got beds all over a hospital across multiple floors of a hospital, and they're still managing to get around their staff of an evening and say, how are you doing? How's it going today? I think the least we can be doing is arranging through our managers and junior managers calls to workers on a sort of consistent known basis. Next slide, please. This is the third risk that I recommend you look at. It's the one everybody's talking about, mental health issues arising from isolated working. A reminder there, again, it's risks to those affected by your undertaking as well as your staff. In this context, that could mean family members. I don't want you to get overly worried about that. I put it on the slide because it's so easily fixed. So in your risk assessment, you would identify this as a risk. Now, many of you in large organisations will already have a golden key to fixing this, which is through your group income protection policies or your Medicare plans. There is bound to be facilities for direct access counselling. Usually you don't even need to go through a GP. Usually in your policy documents, there's a phone number. So simply communicating that to your staff, if you have issues, don't forget, here's the phone number for our insurance policy. You just call that and you're automatically entitled to 6 free counselling sessions. You don't even need to trouble us with the information. You could just get on and have that. So do look into that. Next slide, please. So this is the last slide, and the good news is it's not all one way. I focus there on your duties as employers, but the employees have a duty as well. They need to take reasonable care for their own health and safety. Any equipment you provide, they need to use in accordance with your training and instruction. And critically, they must cooperate and comply with all your COVID-19 procedures and risk assessments. So if you're finding pushback, I've put on the slide there the 2 regulations that require that cooperation from your employees. Okay, so good luck with that risk assessment preparation. Thank you.
Well, we have another poll that Cordelia and Alexandra wanted to ask you, and I'll launch that one now. And one I'm actually quite interested in what the answer is. After lockdown, will you work in the same hours in the office? So as before. So folks, as ever, well, we're up to half the audience has voted in 5 seconds. This is a new record, I think. Fantastic. Give me just a moment here. Well over 80%. I'll just close and share those results with you. And yeah, 68% believe no, they will not be working the same hours in the office. Great. And over to you, Alexandra.
Well, thank you, Michael. And I think that's a very interesting result. And what I'd love to do is run that poll again in 6 months' time and see if people are actually doing what they thought would happen. But essentially, it's the perfect lead into what I want to say, which is that in many ways, I don't think the pandemic necessarily changed working practices, but it has certainly accelerated the level of change. I was certainly seeing a lot more flexible working requests before this. And of course, now everyone's realized that you can work from home. I just can't see that going away. Now, obviously, with a limited amount of time, there's only a certain number of things that I can deal with today. And I just wanted to pick up 3 key areas for you about things which I think will still remain very prevalent and are very important when people do start going back to the office. Excuse me. And so the 3 things that I've picked upon are mental health, which Cordelia touched upon, but I'm going to deal with in a bit more detail. Confidentiality, and finally staff retention. So just because we're lawyers, here's a bit of law. So as you can see, there's a lot of law about mental health. Personal injury is your common law duty of care, what you'd expect if you're knocked over in a car. That exists in the workplace as well. Breach of contract, that's the breach of either the expressed in a contract or the implied term, often of trust and confidence. If you are dismissed for mental health reasons, that can often be unfair. It may also be discrimination under the Equality Act 2010. And the Equality Act is very specific that mental health conditions are capable of being a disability in this context. And if disabled employees have basically two very specific rights, one is to be protected against detriment because of their disability, and detriment can of course include dismissal. The other is that the employer has a statutory duty under the Equality Act to make reasonable adjustments. Finally, I've put there the Protection from Harassment Act 1997. This is only in very extreme cases, but employees who were treated continually badly because of their mental health, that may amount to harassment under the PHA, and that of course is both a criminal and a civil offence. So I've just put up some statistics here. I'm not going to, you can read them faster than I can talk through them, so I'm not going to do that. There's only 2 points I wanted to make. One is obviously that's diagnosis per week, per 100 people, that is per week. The second thing is any statisticians out there are probably saying, well, surely if you've got mixed anxiety and depression, you have also got depression. So isn't there an element of double counting? I would say that MAD, that's mixed anxiety and depression disorder, is a particular recognised condition. But you're right, there will be some double counting there. But nonetheless, I do think it does show the sort of volume of how prevalent this is. And again, it will be interesting when we have them to see statistics pre and post March last year as to whether that has got worse. These are some claim statistics from the Employment Tribunal. The all line is all the claims brought in the tribunal, and that can be for unlawful deductions from wages, unfair dismissal, any form of discrimination, any claim at all. And DDX below is disability discrimination. And you'll see that those cases have been progressively rising at really quite a rate. Now, you may think, oh, well, it's only 8,000 cases, it's not that many. I would say that 99% of cases which are either intimated or actually brought settled, these are claims which actually went to trial, and it is actually very unusual for claims to go to trial. Next slide, please. So lots and lots of problems, but we don't like that. What we want is the solution. So the quote at the top there, that is from the Chief Talent Officer at Manpower. And I think it just really epitomises the position is, you know, it used to be working from home. Now we live at work, everyone works from home. And though a lot of people will want to go back to the office, there's going to be a lot more working at home. So what is the solution to all those legal risks that showed in my first slide? Well, the first one is your policies. And what I would say about policies is that, should have done it on a poll, is when were your policies last updated? You'll see here that I have selected some policies which I would expect most employers to have. If they don't have them, you should. I can get them for you. But it's not enough just to have them. If you did them in 2010, 2015, whenever it may have been, that's simply just not good enough. What they have to do is they have to be live documents, which means that you have to make sure that you're updating them. Even if there's nothing to update, you need to have recorded that you have reviewed them and decided that there was nothing to update. Because to link back to what Cordelia said, what we're talking about here is it's twofold. It's doing the right thing, and it's also being able to show that you've done it. And I have seen this from first-hand experience, that tribunals will just look at policies, and if there has been no updating, employees don't know where to access them, the employer doesn't know whether or not they've read them, then they're just going to be considered as pieces of paper, and they will give you as an employer really very, very little protection. And although these themes are obviously for UK law, for English law, they are very common themes which appear across all jurisdictions. The other thing which you need to be careful of and will help provide you with a solution is in respect of working time. Now, the working time regulations of 1998 have very specific things about working time, and they of course come from the Working Time Directive, which is a European Union directive. The most commonly referenced working time regs are not working more than 48 hours a week, and the need to have a 20-minute rest break every 6 hours. Now, those are things which are much more easily monitored if people are in the office, because you can see if people are there a lot. But when people are working from home, it is much, much harder to keep an eye on that. What I would say is to anyone out there who has a working time opt-out for the 48-hour week in their contract of employment, that isn't good enough. It is often not good enough to have the opt-out in your contract. It needs to be in a separate document. So anyone who's got it in their contract but wants it in a separate document, then please do contact me after the seminar and I can provide you with that. So with managing working time, obviously a key thing is monitoring. That's not a complete answer because obviously people log on and forget to log off, but it's certainly a very good way of checking for alarm bells. And also I've seen things like recharge days, basically an extra day off, or days where there's no meetings, or days where you don't have to reply to email. All those sort of things would have been unthinkable before, but they are now things which many people are considering. Other initiatives I've seen are mediation apps, people having very specific mentors, to allow that one-to-one connection as far as possible. And here at Keystone, we have a pub. Now, I expect you're all thinking, yep, that's another Zoom meeting, and of course, you're very right, that's exactly what it is. But I have to say, it is quite good fun, and it does create much more of a social atmosphere than just a regular team meeting. It's much more of a sort of general catch up. So that's what I wanted to say about mental health, which is essentially keep an eye on it. There's things you can do it and be seen to do it. Moving now on to some things about compliance matters. And the particular issue I'm going to focus on here is some IT related matters. So in her speech on market abuse on the 12th of October, Julia Hoggett, who's the FCA's Director of Market Oversight, made a number of points regarding how much harder it is to police your staff while they're working remotely. And the risks identified, including IT risks, and particularly those relating to individuals using their own devices. And that is what I am now going to concentrate on. So the first thing is this issue about mixing of business data and personal data. Now, when people are in the office, my view is that the tendency to use your own devices is much reduced. So if you're trying to get something out and the IT goes wrong, that temptation, which I know we've all had, to send documents to your personal email just because you've got to work on them and you've got to get them out, isn't so bad if you're in the office because you can get access to IT. If you're on your own, the temptation when you're right there in front of your own computer is much higher. That's one thing. The other thing is that if people are using their personal devices a lot and you physically see them, it is just so much more obvious. So what do you do if you've got an employee who has got your business data on their own device? Well, the difficulty that arises with that, of course, is that if you want to look at their device so you can check if any of your stuff is on it, is that you're then looking at their personal data, and it, maybe very personal data. And that produces lots of problems with GDPR. And GDPR exists in many different forms in many different jurisdictions. Now, there is a way around that. And sorry, last slide, please. There is a way around that. And the way around that is that you need to have a bring your own device policy. And if you have a really robust bring your own device policy, which explains that if people bring their own devices to work, use their own devices for work, you have the right to examine those devices, then you will legally be able to do that. Now, I'm not saying that legal process of looking is very straightforward, but it is perfectly possible. But you've got to have the right policy in there. Next slide, please. So the next thing I'm going to talk about then is going on about confidentiality. Is you'll see here there's the various duties that arise. What I'm going to just bring out there on the express duties is that it's not just what you may think of confidential information may not be confidential. It's got to have a real element of secrecy. It's got to be a trade secret. Now, I don't usually mention case law, but it's such a good name that I'm going to have to. But the case that says that is a case called Facenda, Chicken and Fowler, I kid you not. And that basically says that, you've got to do various things to make it confidential, which I will tell you about in a moment. I also mentioned fiduciary duties there. The reason about people having fiduciary duties is that if you have that duty, it's a very high duty, it's very onerous, and it incurs things which you wouldn't normally find in a contract, like the duty to report your own wrongdoing. It also gives you a specific remedy which allows, rather than having to show loss, that you can ask for an account of profits. And what that really means is if you have very senior people, what you should be doing is making sure that you are marking their...
We seem to have frozen, Alexandra. We do have a number of questions and comments. I was wondering, Cordelia, would you mind coming back in?
Hello.
Hello. Got time for some questions and comments here, and my apologies both to the audience and to Alexandra. There seems to be a technical hiccup, but we could barrel in with a couple of points here. Paul Phillips points out there are workers who have a homeworking contract, i.e. it is their job and place of work. Others are mainly office-based, but are able or permitted to work at home. So he's questioning, is there a legal distinction between home workers and those who are enabled to work at home?
I'm just going to answer that from a health and safety perspective. From a health and safety perspective, they are employees, and you owe them a duty of care. That's the simplest way of putting it. So, Alexandra, in an employment context, the question was about whether there was a difference between, whether there was a sort of technical difference between home workers and workers in the office in an employment context.
Tangi Morgan is asking, she says, most organizations assume that they will have a hybrid workforce going forward. The idea that employees can flex the days in or out of the office. How do you see guidance evolving, for example, risk assessments, to actually reflect this type of flexible working? And additionally, she points out the work from anywhere, WFA, situation. Does the law of the UK, if you're UK domiciled, apply?
So in terms of how's the law going to evolve, you could say the law's already there. There's a duty of care. You owe your staff a duty of care wherever they're working. And we've looked today at your obligations on assessing that risk, responding to that risk, training, supervision, support, whether they're in premises or whether they're working from home. In terms of if you're then perhaps working elsewhere in the world, if they've certainly got a UK employment contract, then you are certainly bound by UK law. And I'm not going to comment on sort of your legal liability in other more remote international places. But as a UK employer, you owe a duty of care to your workforce, no matter whether they've got an employment contract or not.
I do apologise. Everyone's missed my words of wisdom now, but I'm sorry about that. Do carry on.
Okay. Well, we just sort of picked up on the questions coming. Question here from Jane in West London. Is there a danger that increased regulation and compliance needs for employers will discourage employment and increase contracting and the gig economy to the detriment of working folk?
I think that's an excellent question, and I think that's very pertinent, because obviously, as you know, there's been a lot of legislation about 0 hours workers and also cracking down on IR35 to try and get away from that. The reality is that whatever you call your employee, call your worker, what the courts will look at, and indeed what HMRC will look at is the reality of the situation. So I think people might carry on trying it for a bit, but ultimately the world's moving away from that. So hopefully it won't, because of course that just leads to less protection for people.
Mm-hmm. A couple of people here are curious. Could you explain how the Keystone Pub works? Why you're so pleased with it?
It's fabulous.
So how it works is it's a big Zoom, obviously, because there's no other option. But there's various there's a garden and there's some bar stools, and you basically join a table and you can just sort of click and move around. And to start with, of course, it's quite difficult to get yourself off a table because you can't sort of go bye, but you sort of get used to it. And it's because it's the whole firm, not just your team. It does feel much more like a social event.
Okay. Are you using a particular system to do this?
It's called Remco, I think.
Yes, remote.
Other operating systems are available.
No, it's just I think people were quite interested in that idea of applying alcohol, using alcohol for people who are mentally at home under stress. Let's not. No, wait, that's not. I don't think that's quite what we're involved in.
Isn't compulsory, but there's a dance floor, and of course you don't know one actually dances, but it just gives it this kind of festive feeling.
Mm-hmm. A comment rather than a question from Ian Harris. We have been advocates of flexible working and a mixed environment working for decades. He says he thinks it would be a good thing if employers are encouraged even, to move in a more flexible working direction post-COVID. Do you have any thoughts on how you could take this further?
I think that's a very interesting question, because when I was saying pre-pandemic, everyone wanted to work flexibly. Everyone, particularly amongst the younger people, they wanted to work from home. Now, of course, you're getting a pushback of they don't want to work from home anymore, because working from home full time, particularly if you're in a flat share or something, is just disastrous. But I think you'll see, again, it will be it's the zeitgeist, isn't it? You'll see more hot desking, you'll see smaller offices, you'll see much more sort of communal living, I think, within the office. So flexible hours, people coming and going when they please. This sort of idea that you have to tell your manager exactly where you are, that may change quite a lot, all of which is great if you've got the right workforce.
And finally, I'm afraid we're kind of running out of time and people are thanking you for your presentations, but a double point, if I may. This whole bit of COVID assessment, COSH, HSC type work, well, a year ago, there was nobody around who could have advised me at all. And now I rather suspect, like double glazing salesmen, there are tons of people who claim that they know everything about it. And yet I have to rely on experts to inform me. How do I go about assessing these recently found competences? I mean, who is really qualified to advise me, or am I better off to do it using common sense and the government websites, Cordelia?
I was going to say, Cordelia, it's obviously the answer.
I think what you're looking for, so if you have an enormous amount of time and someone is prepared to give you 3 months off your day job, and you're an HR or a compliance officer who is familiar with addressing the complexities of risk assessments, and actually not just the lip service documents that just go in the bottom drawer, but really understand risk assessments. If you're one of those and you've got 3 months off work, go for it. You can do it. It's a question of assimilating the vast amount of information that's out there. That essentially is what you're buying if you're going to an expert. And I would steer clear of anybody who's not been in the business for 20 years and really understands the process.
Okay. And Alexandra, likewise, a number of people would tell me they know what's best for my staff, particularly regarding their mental awareness and stress and health. How do I go about assessing some of these as well? There are a lot of contradictory pieces of advice floating around in many cases about what one should do, how to assess it, how to diagnose it.
So for a lot of people, the go-to place is ACAS, the Advisory Conciliation Service, and that's because it's government-backed. A lot of tribunals will rely, if you've followed ACAS guidance, then that's very helpful if you do end up in a tribunal issue. The other thing is that there's lots of OH people out there. It's just repeat what Cordelia says. You just have to do your research. But ACAS is my go-to place if you're looking on the net.
Okay. Greg Davis naturally points out he's a long-standing professional health and safety consultancy. It's his day job. And one last quick one, if I can squeeze it in, from Ian Sheridan. I guess this affects all of us. Science points to the wearing of masks as a robust part of minimizing infection. How reasonable will it be to require office workers to wear masks?
What the guidance says is, when you've done your risk assessment, you conclude that masks ought to be worn, then you can require your staff to wear masks. Okay. And see the slides earlier, which gave you the authority to require your staff to comply with your systems.
Very good.
Well, can I just add very quickly? Just do remember, some people won't be able to wear them for reasons which may be protected reasons. So case by case, if someone doesn't want to wear it.
Because you will have already assessed your staff and worked out who are the vulnerable ones.
Well, it sounds like you've got all the bases covered, Cordelia, Alexandra. Folks, if I may, just 3 quick rounds of thanks. Firstly, to our sponsors who allow us to range widely and freely, but I think this is a hot topic and one that we need to stay on top of, which I think will be evolving. Secondly, thank you for listening, and thank you for your questions and comments. All those will be fed through to our presenters. And finally, may I thank our presenters, Cordelia and Alexandra. Alexandra, our apologies on whatever happened with the connection, but I'm sure we can have you back and talking about mental health specifically. But both of you, it's been so kind of you to share a lot of your experiences with us today. I'm unable to open the floodgates of applause, as you probably are well aware. That's another disadvantage of working on GoTo and other systems. But I do have a little Korean karmic clapper, which will serve as my means of giving you that applause that you so richly deserve. And may I say thank you again very much for coming on today and appearing here.